Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers, trainers, professor, professionals, official listeners. I welcome all respected doctors and directors. I welcome honorable minister managers. I welcome honorable advocates, retired administrative advisors. I welcome the most honorable President Prime Minister Modi ji. It is really nice time, nice place, nice section that we are defining, explaining, expressing our holy Indian spiritual, social, cultural, educational identities in the form of unity and diversity. Rights and duties arising out of state succession. When an international person takes the place of another international person following international rights and duties arise political rights and duties. No succession takes place in respect of political duties and rights. As remarked by Professor Oppenheim, no succession takes place thereof with regard to rights and duties of the extinct state arising either from the character of later as an international person or from its purely political treaty. Hence the succeeding state is not bound by the political treaties of the former state. The successor state is not bound by the treaties of peace or neutrality entered into by the extinct state, but it may be abundant and uniform to permit an attempt at generalization. The state practice is haphazard and inconsistent. Even the same state adopts different attitudes at different times. When a state relinquishes its life as such through incorporation into or absorption by another state, either voluntarily or as a result of conquest or annexation, the general opinion of international jurists is that treaties of the former are automatically terminated. The result is said to be produced by reason of complete loss of personality consequent on extinction of state life. Thus, the forcible incorporation of Hanover into the Prussian kingdom destroyed the previous treaties of Hanover. The admission of Texas into the United States of America by joint resolution extinguished the treaties of the independent Republic of Texas. The position was same when Korea merged into Japan. No succession of rights and duties ordinarily takes place in such cases, and as political and personal treaties presuppose the existence of a contracting state, they are altogether extinguished. It is debatable point whether succession takes place in cases of treaties relating to commerce or extradition. But here again, majority of writers are of the opinion that they do not survive merger or annexation. When as a result of amalgamation or merger, a state loses its full and independent power of action over the subject matter of a treaty previously concluded, the treaty must necessarily lapse. Thus, treaties of alliance or of arbitration or of neutrality or of any other political nature fall to the ground with the extinction of the state which concluded them. Reference may also be made between Prussian and America, which was entered into in 1882, could be given effect to affirmative. It was pointed out inter alia that the constitution of the German Empire left sufficient independent power and sovereignty to the states composing the confederation to enable them to act upon these treaties, and it was observed by Fuller CJ, who delivered the opinion of the court that where sovereignty in respect of the execution of treaties is not extinguished and the power to execute remains unimpaired as void, but where the power of the state concerned to execute the treaty is altogether gone, the treaty cannot but be regarded as void. Local rights and duties, a genuine succession takes place in respect of local rights and duties, in respect of land, rivers, roads, railways, etc. Therefore, the succeeding state succeeds the rights and duties of the former state. In German, shatters. In Poland, the Permanent Court of International Justice, in its advisory opinion, held that private rights do not end by the change of sovereignty. Fiscal property debts. According to Oppenheim, succession takes place in regard to fiscal property, but he adds that no private person gets the right to claim the old debts from succeeding international person. So far as the question of foreigners is concerned, the position is a little different. They may seek the protection of their government and may pressurize the succeeding international person to pay the whole debts, public debts. There is a controversy in regard to the succession of public debts. Jurists are of the view that it depends upon the discretion of the succeeding international person whether to pay the public debts of the former state. Part 4 of the Vienna Convention on State Property. Archive and Debts 1983 deals with state debts, that is, the financial obligation of a predecessor state towards another state or an international organization. Article 36 of the Convention provides that the succession of a state does not as much as such affect the rights and obligations of creditor. Further, when the successor state is newly independent state, no state debts shall pass to the new state unless an agreement between the two states provides otherwise. According to the convention, such an agreement, however, shall not infringe the principle of the permanent sovereignty of every fundamental economic equilibria of the newly independent state, Article 38. In case of separation of part of the territory, the state that of the predecessor state should pass to the successor state in an equitable proportion, taking into account the property, rights, and interest passing to the successor state, Article 40. Vienna Convention on Succession of States' Property, Archives and Debts 1983 was signed on 8 April 1983. It has yet not come into force for becoming effective. It requires 15 states to be bound by it. As of 5 August 2009, only 7 states have so far ratified it. One of the main flaws of the convention is heavy reliance throughout on equity as a guiding principle. Another defect that has been pointed out is undue emphasis on succession of states in a simple case of independence, typically from a colonial power. Moreover, this convention does not seem to be a useful guide to settling the complex problem of the succession resulting from the breakup of a state. What are the contracts? Most of the jurists are of the view that the succeeding state should be bound by the contracts entered into by extinct state. But in the West, Rand Central Gold Mining Company Limited versus King, the King's Bench of England ruled just the reverse. In this case, the court ruled that the succeeding state is entitled to decide whether it would accept the financial obligations of the former state. The facts of this case are as follows. Western Central Gold Mining Company Limited was a registered company in England. It was engaged in the work of digging of gold mines in Transvaal. In October 1896, 99, two parcels containing gold were seized by the officers of the South African Republic. According to the law prevailing at that time, it was the responsibility of the South African Republic to return the shared parcels of gold or equivalent money in view of the parcels. Meanwhile, war broke out between Britain and South African Republic and the latter was conquered by Britain on October 11, 1899. Western Central Gold Mining Company Limited filed a petition to claim the parcels of gold on the ground that after conquering the South African Republic, the obligations of the South African Republic automatically became the obligations of Britain. It was therefore argued that the British government was liable to return either the parcels of gold or pay its value in money. The court rejected the contentions of the company and held that the conquering state is not liable to fulfill the private contractual obligations of the conquered state. International law does not impose any obligation upon the conquering state to fulfill the obligations of conquered state. The court further observed that acts of state are beyond the jurisdiction of the municipal court. Conquest of South African Republic being act of state, the appellant company can get no relief in a municipal court. It may therefore be said that much depends upon the discretion of the succeeding state. In the absence of express understanding, a conqueror assumes no obligation of the conquered state. There is a difference between the private right of individuals in private property and contractual rights which are sought to be enforced against the sovereign Lord Alverstone observed. It must not be forgotten that the obligation of the conquering state with regard to private property of private individuals, particularly by land, as to which the title had already been perfected before the conquest or annexation, are altogether different from the obligations which arise in respect of personal rights by contract. Secession of territory does not mean the confiscation of the property of individuals in that territory. In its illustration, a company registered in India was carrying on trade in Sikkim before it became part of India. The government of Sikkim confiscated a few consignments sent to company's office in Sikkim from India. When thereafter Sikkim became part of India, the company claims the consignments or their value from the government of India. The facts of this problem resemble that of the case of Western Central Gold Mining Company Limited versus King discussed above, as held in this case. Conquering state, or for that matter the state that is India, in which new state that is Sikkim merges, is not liable for the acts of later state that is Sikkim. Moreover, merger of state is an act of state which is beyond the jurisdiction of a municipal court. The government of India is not therefore liable to return the consignments or their value. As a matter of fact and practice, it depends upon the discretion of the succeeding state, that is India, to deny or accept the claims of the company. Concessionary contracts, although much depends upon the discretion of the succeeding state so far as the contracts in general of the former state are concerned, the position is different in respect of the concessionary contracts. By concessionary contracts, we mean the contracts through which certain concession, such as digging of mines, laying of railways, etc., are given through contracts. These are mostly of local nature. Succeeding state may or may not be bound by such depending concessionary context upon the facts and circumstances of each concessionary contract. In Prem Chimber versus the Union of India, where the government of India rejected the application of a former Portuguese citizen for extension of the period of license granted to him by the then Portuguese government. The Supreme Court of India held in such a case the residents of the territories did not carry with them the rights which they possessed as subject of the ex sovereign, and that as subjects of the new sovereign they had only such rights as are granted or recognized by him so far as the relations between the subject and the sovereign are concerned. Further, whether new sovereign has liabilities arising thereunder is a question of fact depending upon the new sovereign after Portuguese territory. On December 20, 1961, Portuguese territory was merged in India and the petitioner adopted Indian citizenship. About 3 months before merger of Portuguese territory in India, the petitioner had obtained a license for importing goods worth about 10 lakhs pounds. On the basis of said license, he had even advanced some money. After acquiring Indian citizenship, he requested the government of India to Supreme Court and contended that the rejection of his application amounted to the violation of his fundamental rights mentioned in the Constitution, and what he was discriminated which was also contrary to the provision of the Constitution, but the Supreme Court dismissed his petition. State of Gujarat versus Vora Fideli and State of Rajasthan versus Shamlal also deserve mention in this connection. What are laws so far as the laws of the former state are concerned? Civil law continues until it is changed by the succeeding state. Unliquidated damages for torts. No succession takes place in respect of unliquidated damages for torts. This was held in Robert E. Brown's claim. The facts of this case are as follows. Robert E. Brown was an American citizen in 1894. He went to South Africa and started the work of digging gold mines. After some time, the head of the state of South Africa declared that in the eastern part of the area, state would undertake the work. Robert Brown submitted an application of license for carrying on digging of gold mines, but it was rejected. Later on, the government withdrew its earlier order for carrying on digging of gold mines. Robert E. Brown filed a suit in 1895 for recovery of compensation, but the case could not proceed because in the meantime Great Britain conquered South Africa and incorporated it in its empire. The government of America contended that her citizen Mr. Brown had been authorized to carry on digging of gold mines, but this right was subsequently snatched from him before South Africa was annexed by Britain. It was agreed to refer this dispute to arbitrators. The arbitrators had to decide mainly two questions. One is whether South Africa refused to do justice to Robert E. Brown, and two is if justice was denied to him, whether the succeeding state of South Africa would be responsible for the loss and damages. In other words, whether Britain was liable to pay compensation. In reply to the first question, the arbitrators held that justice was denied to Robert E. Brown because if the case had proceeded, South Africa would have been liable to pay damages. In reply to the second question referred to them, the arbitrators decided that the peace agreement under which South Africa surrendered before Great Britain did not undertake the liability for torts committed by South Africa. Hence, Britain was not liable. But if the former state had accepted or had decided to pay the compensation, then the succeeding state should pay the damage for torts. Nationality. The nationals of the former state lose their nationality at the extinction of the state and become the nationals of new international person. In this connection, it may, however, be noted that generally such nationals are given a certain period within which they have to decide whether they continue their loyalty towards the former state or will accept the citizenship of the succeeding state. Succession to property in foreign state. As regards the succession to property in foreign state, jurists are of the view that succeeding states become the successors of such property. Part 2 of the Convention on Part 2 of the Vienna Convention on State Property, Archives and Debts 1983 deals with state property. Article 11 of the convention provides that unless otherwise agreed, the passing of state property will take place without compensation. Article 12 provides that property rights and interests owned by a third state should not be affected by succession of states. Article 13 asks the predecessor state to take all measures to prevent damage or distinction to state property which passes to successor state. As regards succession in case of newly independent states, Article 15 allows the special reference to be made to bilateral agreements between the predecessor state and the newly independent state, but it shall not infringe the principle of the permanent sovereignty of every people over its wealth and natural resources. Succession to state archives. Article 25 of the Vienna Convention on State Property, Archives and Debts, 1983, lays special emphasis on preserving the integral character of grounds of state archives of the predecessor state. The convention provides that the passing or appropriate reproduction of state archives of the predecessor state to a newly independent successor state should be determined in such a manner that each of those states can benefit as widely and equitable as possible from those archives. Bilateral agreements between the two states should not infringe the right of the peoples of those states to development, to information about their history, and to their cultural heritage. Succession of states in respect of treaties. The traditional doctrine of the state succession in respect of treaties have been rejected by the large number of newly independent states. These newly independent states have relied upon the rules of moving treaty frontiers and clean state. These rules are not simply reaction against the inheritance treaties and devolution agreements but were necessitated by the changing times and circumstances. On 23 August 1978, Vienna Convention on Succession of States in respect of treaties was adopted. The convention entered into force on November 6, 1996. The provisions of the convention show that the clean state rule has been followed and due recognition has been given to the consent of states. The clean state rule is similar to navigate to negative theories and communist theory discussed earlier. According to clean state rule, a newly independent state is unencumbered by the obligation and commitments of the predecessor state. It has therefore full freedom to continue or discontinue the treaties of the predecessor state. The moving treaty in the moving treaty frontiers rule is based on the association of a territory with an already established state and on the basis of the prior legal actions are duly. A newly independent state is entitled to claim its succession to multilateral treaties. Article 1 of the Vienna Convention on Succession of States in respect of treaties 1978, which deals with the scope of the convention, provides that the convention applies to the effects of a succession of states in respect of treaties between states as regards agreement for the devolution of the treaty obligation or rights from a potential state of a state to a successor state. Article provides that the obligation or rights of a predecessor state under treaties in force in respect of a territory of at the date of succession of states do not become the obligations or rights of such state towards other state parties to those treaties by reason only of the fact that the predecessor state and the successor state have concluded an agreement providing that such obligations or rights shall devolve upon the successor state. So is the effect of, as provided by Article 9, Unilateral declaration of successor state regarding treaties of the producer state. Article 11 of the Convention, which deals boundary regimes, clearly provides that a succession of states does not such as effect a boundary established by a treaty or obligations and rights established by a treaty and relating to the regime of a boundary. Obviously, to avoid chaos regarding established situation, clean state rule does not apply here. Article 15 of the Convention deals with succession in respect of part of territory. It provides when part of the territory of state or when any territory for the international relations of which a state is responsible not being part of the territory of that state becomes part of the territory of another state. Treaties of the producer state cease to be enforced in respect of the territory to which the succession of states relates from the date of the succession of states and treaties of the succession state are in respect of the territory to which the succession of state relates from the date of the succession of states unless it appears from the treaty or is otherwise established that the obligation of the treaty to that territory would be incompatible with the object and purpose of the treaty or would radically change the conditions for its operation. As regards the position of newly independent states in respect of the treaties of the predecessor state, a general rule is laid down in Article 16, which provides that the newly independent state is not bound to maintain the treaty in force or to become a party to any treaty by reason only of the fact that at the date of the succession of states, the treaty was in force in respect of the territory to which the succession of states relates. This provision clearly follows clean states rule. Article 24 deals with conditions under which a bilateral treaty is considered as being in force in the case of a succession of states. It provides a bilateral treaty which at the date of a succession of states was in force in respect of the territory to which the succession of states relates is considered as being in force between a newly independent state and the other state party when they expressly so agree or by reason of their conduct they are to be considering as having so agreed. So far as the position between the producer state and the newly independent state is concerned, Article 25 provides that a treaty which under Article 24 is considered as being in force between a newly independent state and the other state party is not by reason only of that fact to be considered as being in force also in the relations between the producer state and the newly independent state. A brief reference may also be made to the provisions of the Convention relating to uniting and separation of states, Article 31, which deserves a special mention in this connection, provides when two or more states unite and so form one successor state. Any treaty in force at the date of succession of state in respect of any of them continues in force in respect of the successor state unless the successor state and the other state party or state parties otherwise agree, or it appears from the treaty or is otherwise established that the application of the treaty in respect of the successor state would be incompatible with the object and purpose of the treaty or would radically change the condition for its operation. Article 34, which deals with succession of states in cases of separation of parts of a state, provides as follows: when a part or parts of territory of a state separate to form one or more states, whether or when not the predecessor state continues to exist, any treaty in force at the date of succession of states in respect of the entire territory of the predecessor state continues in force in respect of each successor state so formed. Any treaty in force at the date of succession of states in respect only of that part of the territory of the predecessor state which has become a successor state continues in force in respect of that successor state alone. Paragraph 1 does not apply to the states concerned otherwise agree, or it appears from the treaty or is otherwise established that application of the treaty in respect of the successor state would be incompatible with the object and purpose of the treaty or would radically change the condition for its operation. As regards multilateral treaties, Article 17 provides that a newly independent state may, by a notification of succession, establish its status as a party to any multilateral treaty which, at the date of the succession of states, was in force in respect of the territory to which the succession of state relates. But this rule does not apply if it appears from the treaty or is otherwise that the application of the treaty in respect of the newly independent state would be incompatible with the object and purpose of the treaty or would radically change the conditions for its operation. Similarly, when according to the object and purpose of the treaty, the participation of any other state in the treaty must be considered, requiring the consent of all the parties. The newly independent state may establish its status as a party to the treaty only with such consent as regards participation in treaties not in force at the date of the succession of states. Article 18 provides that a newly independent state may be a notification establish its status as a contracting state. It at the date of succession of states, the predecessor state was a contracting state in respect of the territory to which that succession of state relates. As regards succession to reservation, Article 23 provides that when a newly independent state establishes its status as a state party or as a contracting state to a multilateral treaty as a notification of succession under Article 17 or 18, it shall be considered as maintaining any reservation to that treaty which was applicable at the date of the succession of states in respect of territory to which the succession of states relates unless when making the notification of succession it expresses a contrary intention or formulates a reservation which relates to the same subject matter as that reservation. The convention also contains provision for settlement of disputes in respect of the application of the conventions. Provisions relating to consultation and negotiation, conciliation, judicial settlement, and arbitration settlement by common consent and other provisions in force for the settlement of disputes are contained in Article 41 to 45. This convention became effective on November 6, 1996. The convention required 15 ratifications to become effective. So far, 21 countries have ratified it. This convention has proved to be controversial because it distinguishes between newly independent states and cases of separation of parts of states. Article 16 states also newly independent states receive a clean states, whereas Article 39 1 states that all other new states remain bound by the treaty obligations of the state from which they separated. Moreover, after Article 17 states that newly independent states may join multilateral treaties to which their former colonizer were a party without the consent of all other parties in most circumstances, whereas Article 9 states that all other new states only join multilateral treaties to which predecessor states were a part of with the consent of other parties. Succession regarding membership of the United Nations. The question of the succession regarding membership of the United Nations arose from the first time after the partition of India into India and Pakistan. India was originally the member of the United Nations, having signed the United Nations Charter at San Francisco. Later on, it was ratified by the government of India after that after participation. After partition, Pakistan claimed that since it was a part of India, which was an original party to the United Nations Charter, it should get the membership of the United Nations in succession automatically. The General Assembly at the United Nations rejected this claim of Pakistan. According to General Assembly, when a state becomes international person, it can become the member of the United Nations only after it is admitted in accordance with the provisions of the Charter. That is to say, a state to be admitted to the United Nations should apply for the membership. A state is admitted as the member of United Nations by the decisions of the General Assembly by 2 by 3 2 by 3 majority of the members present and voting on the recommendation of the Security Council. Thus, the principle of succession does not apply in case of the membership of the United Nations. Succession in respect of international organizations ordinarily. The succession of international organizations depends the continent, upon the constituent instrument or special agreements, while as a rule, the evolution of rights and compen- competencies is governed either by the constituent instrument of the organs in question or by special agreements or decisions of their organs. The requirement of the requirements of continuity of international life demands that succession should be assumed to operate in all cases where that is consistent with or is indicated by the reasonably assumed intention of the parties as interpreted in the light of the parties of the organization in question. The law regarding succession of international organization has been clarified by the International Court of Justice in its advisory opinion of 1950 in these following cases: the status of Southwest Africa, Trusteeship Council of the United Nations succeeded to all rights and duties of the mandatory commission. That is to say, all the territories which were under the mandatory commission came under the control of the Trusteeship Council. The Southwest Africa also came under the control of the Trusteeship Council. In the beginning, South Africa accepted the control of the Trusteeship Council and sent its reports, that is, to the United Nations in this connection. But later on, South Africa contended that after the extinction of the League of Nations, Southwest Africa ceased to be under control of any international institution and became a part of the South Africa, and as such, Trusteeship Council had no control over it. Consequently, South Africa used to follow the directions and control of the Trusteeship Council. In 1950, the General Assembly referred this matter to the International Court of Justice for its advisory opinion. The International Court of Justice advised that Mandatory Commission was an institution of international status, and the Mandatory Commission had created an international status of Southwest Africa, which could not be modified unilaterally by South Africa. Besides this, the function and purpose of the Mandatory Commission and Trusteeship Council are same, keeping a view the desirability of the requirement of continuity of international life. The Trusteeship Council succeeded in all the functions of the Mandatory Commission. Consequently, the Southwest African Republic was a trust territory under the control of Trusteeship Council, and hence South Africa was bound to follow the directions and control of the trusteeship system of the United Nations. The conclusion that the United Nations succeeded to the supervisory functions of the League of Nations in the matter of mandated territories from party from the principle adopted by adopted by the court that the regime established for the mandates was of an international status as distinguished from a purely contractual agreement. The other principle that the court applied was that if the nature, functions, and purpose of the new international organization are the same, succession may take place in regard to the rules and powers of an international organization. Question of application of the rules of state succession in respect of division of India into two independent states, India and Pakistan. After the passing of the Indian Independence Act 1947, India and Pakistan became two independent dominoes. There was no controversy regarding the status of Pakistan. Pakistan emerged as a new state in the horizon of the international community, but a controversy arose in respect of India as to where India emerged as a new state, having acquiesced new international personality. By the Independence Act of 1947, British India was divided into two independent states on the basis of equality, on the basis of international agreements, rights, property, obligations, etc. were divided between the two states. It was not, therefore, a case of secession. The Supreme Court has expressed the same view in Virendra Singh versus State of UP. In fact, it was a case of dismemberment of British India. Therefore, the principle of state succession will apply to determine the rights and obligations of both the states. So far as Pakistan is concerned, there took place state succession in respect of local rights and obligations, the rules of international law of state succession applied in respect of law properly situated in foreign countries, etc. But there was no state succession of political rights and duties. Consequently, it was not bound by political treaties earlier entered into by Britain. In respect of India, also the above mentioned rules of international law applied, but the position is not clear in respect of India. Although in respect of India also, the rules of state succession applied in some respects, such as local rights and duties, law, property situated foreign in countries, etc. But in other respects, India's international status continued to be the same as was during the British period, exercising its influence. Britain got India become a member of the League of Nations and International Labour Organization in 1919. Even after India became an independent sovereign state, India continued to remain the member of these international organizations. Similarly, India had become an original member of the United Nations and continued to remain so even after she became an independent sovereign state. Thus, even before independence, India's international personality had been recognized. But a similar thing did not happen in respect of Pakistan. After emerging as a new independent state, Pakistan claimed that it should also be recognized as an original member of the United Nations because it became an independent state in consequence of the division of the subcontinent of India into India and Pakistan, but the claim of Pakistan was rejected by the General Assembly of the United Nations. According to the General Assembly, whatever the territory, population, etc. of the state after emerging as a new state, it can become a member of the United Nations only in accordance with the provisions of the UN Charter. On the other hand, India was not regarded as a new state. India was not original member of the UN and continued to remain so even after independence. I thank all my brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professor, professional, officer, official, listener, learner. I thank all honorable minister managers. I thank all respected doctors and directors. I thank all adorable advocates, administrative advisors. I thank the most honorable President Mr. Modi. Thank you very much. Nice to see all of you. Thank you.